Welcome to Divorce Dialogues. I'm Catherine Miller. Divorce Dialogues brings expert guests to the airwaves to talk through your divorce questions and fill in the gray areas about separating. From thinking about divorce to how to behave during divorce to what to do after, this is Divorce Dialogue. Welcome to Divorce Dialogues. I'm Catherine Miller. I'm the founder of the Miller Law Group and a trainer at the Center for Understanding and Conflict, and I am on a mission to change how people divorce and help them divorce with dignity. And my guest today is Michael W. Goldstein. He's a seasoned New York attorney with over 3 decades of experience in real estate planning and business law. He's known for his practical insight and compassionate approach, and he helps his clients navigate complex legal issues with clarity, especially during life transition like divorce. Welcome, Michael Goldstein, to the show.
Thank you. Nice to be here.
And one of the things that I think is really, in my experience, is that the marital residence, the home that the people live in, is often the largest shared asset, or that and a pension sometimes is too. And I think that can create a lot of legal pitfalls. What are some of the most common ones that you see in dividing real estate during divorce, and how could they be avoided?
Well, I mean, generally speaking, okay, like you said, the marital home would certainly be the most common real estate issue in a divorce. Also, sometimes the parties may own, investment property as well that they rent out or whatever. Typically, I'm not the one that's doing that's representing the client, either client in the divorce action. So typically in the divorce decree, the judge is going to be deciding what happens to the jointly owned real estate. But there are some situations where that is not addressed in the divorce decree. And that in my experience is probably more common when we're not talking about the marital home, but rather investment properties. So, there are a fair amount of times where clients have come to me and they said, they got divorced and now they need to deal with this jointly owned property. And then, I ask, of course, was that addressed in the divorce decree? And they'll tell me, no, it wasn't. So then we go from there.
And so what are some of the pitfalls that people experience when they face that situation?
Well, that's basically the same type of situation as if it weren't involved if there was not a divorce. In other words, whenever you have two people that are owning a property together and one of them wants to sell and the other one doesn't, what inevitably happens, if it can't be resolved, is a partition action. And a partition action is basically, it's a lawsuit asking the court to direct that the property be sold. 9 out of 10 times, the lawsuit will get resolved before a judge gets to the point of making that decision. But there are monetary issues that typically arise in a partition action or in any kind of dispute involving jointly owned property. And that typically stems from the beginning to the end. In other words, who put the money down for the down payment? Was it shared equally, or was it one party put most of it and the other one put a small amount or nothing? And then the next question is who was paying the mortgage, and then who was paying the real estate taxes if that wasn't part of the monthly mortgage bill, and then who was paying for the maintenance and repair of the property, and then what was happening with the income from the property? Was it being divided? Was it being used to pay the monthly expenses, or was one party just grabbing the income and pocketing it, and then the other one, was left holding the bag, being responsible for the monthly payment? So, you have all of those financial issues that come up.
Let me ask you this, Michael Goldstein. If you and I buy an investment property together, not married, as we're not,
Right.
and
Right.
whatever happens in that, how is the unwinding of that business relationship different than when a husband and wife buy a real estate property together?
It's not really different. I mean, in other words, the marital home, as we said, that's, usually addressed in the divorce decree. But as far as investment properties, that may or may not be addressed in the divorce decree. And if it's not, then it's basically the same thing as you and I buying it. Now, the one thing I thought you might have mentioned is what advice would I have if you and I were buying the property? The first advice I would have, whether it was you and I or a client of mine, is that there should be a written agreement. So, and that, of course, can be in the marital situation as well, which basically states, what's going to happen if one party wants to sell, and is it going to be 50-50? And also during the ownership, how are the expenses going to be addressed? because I've seen this so many times, not just in the post-marital situation, but brother and sister and, two friends, whatever it might be. Many times, they're blood relatives and they can't agree. And so you have all of those issues. But if you have that worked out in advance in a written agreement, then it makes things a lot easier. And one of the other issues, by the way, aside from the ones I mentioned about who's been paying and who's been collecting the rent, is who's been living there. So what you have a lot of the time also is in these family situations, could be in a I guess it could be in a marital situation if they were separated prior to the divorce, is that one party may be living in the property, paying no rent. And so then that gets figured into the mix also in terms of, sort of debits and credits, basically. If one party was living there not paying any rent, that's sort of equivalent to one party renting it out and collecting all the rent and not sharing it with the other side, with the other co-owner. So, you have all that mix plus the expenses.
Yeah, so I think that's such a really great advice to sort of go back to what you said at the beginning of that, which is to have a written agreement. Right now, I've got so many former clients who got divorced 5, 10 years ago, repartnered with someone they don't plan to marry, but they're living with them. They're living their lives together. And oftentimes that includes buying property together. Or
Right.
one person buys property and they're going to use it together. One person he buys property and the other one works to improve that property and they're going to use it together. And so
Exactly.
clarity as to what happens during their who's going to be responsible for the payments, what happens if they rent it out, what happens if they break up and no longer want to share that property. So we're doing a lot of these sort of tenants in commons agreements or putting things into LLCs and doing LLC agreements that really treat this property as an investment that the people they're in a relationship together, but you just don't know what's going to happen. What do you think about that?
Yeah, I think that all makes sense. But keep in mind, just having the LLC alone without the agreement doesn't
Well, you
completely
need the
solve that.
operating agreement. You need the
Yeah,
operating agreement that
exactly.
specifies
Right.
all of that kind of thing.
Right.
Because, and just for our listeners, you need that agreement because what you remember is what you agreed to today. 5 years from now, A, you're not going to remember it so well. And B, the other person's going to remember it differently. How many
Exactly.
have you had a relationship? Don't you remember last week when I told you about that party we were going to? You can't,
Right.
you never told me that. I did too tell you that. If that happens in your life with a party or picking up the kids or, dropping off the dry cleaning, it's definitely going to happen with something like this. Michael Goldstein, do you agree with that?
Right. Absolutely. And even with the LLC and the LLC operating agreement, I've represented people, two members of an LLC owned a condo that they rented out, and they still got into a dispute which resulted in litigation. And that was primarily, that was like one party just usurped control of the finances, locked the other party out of the bank account, and then my client was accusing the other party of, basically dissipating the assets of the limited liability company, spending money on personal and family expenses, just all kinds of things like that. And it becomes like this whole record keeping thing. And I mean, they're even, he wasn't pulling this out of the air. I mean, there were credit card statements that showed clearly personal expenses that were being paid out of the LLC's credit card, so you have all of this stuff, as much as you try and avoid it, but a well drafted agreement can address basically all of these things if it's really done properly, and sort of solve the problems before they arise or as they arise, before they accelerate to a point of being unresolvable.
Absolutely. Let's turn our attention back to the marital residence, what we call like the homestead, whatever it works for you in the jurisdiction that the listener is in. And a lot of times people want to co-own a property that young children are in or even older children are in for a period of time. Say one person's going to live there, they're going to co-own for 3 years, 5 years, 2 years, 10 years, and then they're going to sell and buy out. And or one person is going to buy the other person out today. And in a situation where someone lives in a co-op or a condo, or there's a loan, like from a bank. There are some complications there with changing of title. And I'm wondering what your experience is, first of all, with the co-op and co-op boards and condo associations. How do they react when one person's moving out and is going to be transferring title from, husband and wife, or husband and wife to husband, or husband and husband, or wife and wife to one or the other?
Okay, so there's a couple of issues there. Okay, if it's husband and wife own the property and now the agreement is that one party is going to leave and they're going to transfer ownership to the remaining spouse, the only real issue with that is that the co-op, particularly a co-op, might then say, well, we approved both of you to purchase this based upon your joint finances, but now it's only one of you and your finances don't meet our criteria. So in that situation, I've never seen something like that where they were able to, stop that from happening entirely, but they could possibly impose certain financial obligations, which are giving the co-op some financial security. Like, for instance, they might say, we want you to put 6 months worth of maintenance charges, deposit that with us, meaning the co-op corporation, to hold in escrow so that in case you miss 1 or 2 or 3 or whatever months of payments, we have this to pull the payments from. So that's one possibility that I've seen. Another thing, basically, I mean, if this wouldn't happen if it was jointly owned, but if you had, let's say, a situation where, let's say, the husband owned this individually and then they're now getting divorced, and as part of the divorce settlement the wife is going to get this and live there, the co-op could do the same kind of thing and say, well, okay, but we never interviewed her, we never approved her from a financial point of view, and we never approved her from a personal point of view, since the co-op has essentially unlimited discretion. So that can be possibly an issue. I mean, I had something that was analogous to that. It wasn't in a marital situation, but it was a individual owned a co-op apartment, and he left that. He was elderly, and he left that property to my client in his will. Well, that was fine, except that the co-op said, "Yeah, you've become the owner, but we don't want you living there." So basically, they forced him to sell it, and he wanted to live there. So the issue there was primarily his finances. I mean, he was like a full-time student and, only working part-time, so he wasn't really earning enough to justify, from their perspective, the maintenance payments. But they also, I think, had some other issues with him, where he may have had some personal conflicts with members of the board or whatever, during the time that it was owned by the person who died. So, we had to sell it. I mean, we didn't have a choice.
Yeah, and that can happen. I think that it's something that people really need to understand is that those co-op boards have a lot of power over
Yes.
a property, right? That might seem like it's your property, but really you own shares in a corporation that owns the building, and that gives them a lot of power.
Exactly. And the same thing, like you were saying with the children. In other words, you have, let's say, whatever, a husband and wife, and let's say they're getting divorced and they're going to part ways, and as well as this property, but they'd like their children to live there for X amount of years. If the co-op is going to say, well, we want to interview the children, and see that they're okay from a personal perspective, and then at the same time, if they're going to transfer ownership to the children, that's probably going to be a problem as far as the satisfying the co-op's financial requirements. But if the parents are going to remain the owners for a period of time while the kids live there, and so therefore financially it's the parents, then that shouldn't be a problem. But they'll still probably want to interview the children, just to make sure that it passes that aspect of the personal, part of it.
I'm Catherine Miller, and you're listening to Divorce Dialogues, a podcast dedicated to educating people about divorce related topics so that everyone can divorce with dignity. subscribe to the podcast wherever you listen to podcasts to be sure that you don't miss an episode. And I'm talking today with Michael Goldstein about sort of the ancillary business things that sometimes hit people with divorce. We've been talking about real estate, but Michael Goldstein, I'd like to turn your attention to estate planning. A lot of times people come in and they're like, well, I definitely want to do something so that my spouse doesn't inherit everything while we're going through this divorce process. So, what is the first thing that someone should do with their estate plan when they're heading toward, or they think they're heading toward, a divorce?
Well, first of all, one of the things that people oftentimes forget to do is to change beneficiaries on the will, on life insurance policies, to change the payable on death, provision for bank accounts and for investment accounts. So, all of those things can clearly result in an unintended consequence if let's say that one spouse dies and now everything is going to this, what was going to be the ex-spouse, and that was certainly not what was intended. I'm sorry, go on.
No, I was just thinking that way in which that's really important is on healthcare proxies, living wills, things like that. I think that those things are very personal. It's not just money, and,
Right.
and you're going to be there to suffer the consequences. So, what are your thoughts about that?
Well, yeah, the same thing applies. I mean, if it's a situation, sometimes you have these situations where a husband and wife divorce, but they remain best of friends, for the remainder of their lives. That's probably unusual. But in those situations, yeah, you might have each spouse might still want to have their trusted ex-spouse as the one making healthcare decisions for them. But I would say in 9 out of 10 cases, or maybe 99 out of 100, the last thing that a party would want who's being divorced is to have their ex-spouse be the one to decide whether the doctor should detach life-saving equipment or any kind of make any kind of medical decision for them, because that might sort of give the other spouse a legal, almost a legal right to terminate their life, so that's certainly something that you'd want to change as well. And by the way, one of you mentioned about business, but we didn't really get into that. And that's another thing is you have a spouse that owns a business, and particularly when they own that business with other partners who are not related to the spouse. So usually in those situations, if it's a corporation, a shareholders agreement; if it's a limited liability company, the operating agreement. And that has various provisions, including what happens when a partner wants to withdraw from might say partner, or it could be a member or shareholder, whatever it is. But one of the owners wants to withdraw from the business, or one of the owners dies. And what happens in that situation? And usually, the thing that each of the owners is probably most fearful of is that one of their co-owners dies and then their spouse steps in their place. And I guess you would, it's sort of like the evil spouse is now, coming in and trying to dictate how to run the business when they may very well know nothing about the business, and that type of thing. So usually, as part of those agreements, there are provisions that prevent that from happening. And there's buyout provisions. So basically, and this is whether it was a divorce, usually not a divorce, but just in a marital situation. They still don't want the spouse, coming in to replace the co-owner. So usually in those situations, there's buyout provisions. So, and it's usually funded with a life insurance policy. So it's not that they're trying to cheat the surviving spouse. It's just that they don't want to have to deal with that unknown person
They want to be in
in
business
management.
with them.
Exactly. But that person will cash out and get their share of the business. They just won't be running the business.
You're listening to the Divorce Dialogues podcast, and I'm Catherine Miller. Divorce Dialogues has been educating people about divorce and relationship issues for over 10 years. Please subscribe to the podcast, and don't forget to check out our previous episodes on the podcast website, divorcedialogues.com. And I'm talking today with Michael Goldstein about real estate and estate planning issues surrounding divorce. And Michael Goldstein, if people want to find out more about you or contact you, how can they do that?
They can visit my website, which is www.atty1.com. So that's like a short for attorney, ATTY, the number one.com, or they can call at 212-571-6848. That's 212-571-6848.
And Michael Goldstein's contact information will be in the show notes as well. Before we end, I really do want to talk about trusts. Trusts can seem like, well, that's something that the super, super wealthy do. And it is a really effective way to protect assets from divorce or from anything else, bankruptcy, potentially creditors, or potentially bad decisions. So I'm wondering if you think that trusts can be a smart tool in divorce planning, or really are they just for the super wealthy?
No, trust can be helpful for several reasons. One, is that having assets in a trust makes it easier when a person dies because the trust assets don't go through the surrogate's court. Well, in New York, it's called the surrogate's court, but in whatever state they're in, I can't give advice outside of New York, but basically it's it passes outside of the will and outside of the estate. So it saves everybody time and money. The other thing is, I mean, trusts, like you said, can have those kind of benefits as well in terms of protecting the assets. And you can have trusts where, let's say, the property is held in trust for someone and there's a trustee. There may be different provisions as to the trustee's discretion in releasing the assets. Like, let's say it's an investment account, or a bank account or something of that nature. So it can have what spendthrift provisions, basically, like if you have let's say you want to leave or give all this money to your child, but you want to make sure that they don't spend it all in 10 days. So the trustee is basically doling out the money as needed in accordance with the directions that are in the trust. So it might be used, for tuition, for education, with a certain sort of stipend or whatever, for expenses on a monthly basis or however, or for, let's say, capital expenses, like maybe to buy a new car or something of that nature, but, not basically to prevent the recipient, the beneficiary, from, just pulling out all that money and spending it in Las Vegas or whatever, and then the whole thing's gone.
Michael Goldstein, you've been practicing since 1985, so you've got a lot of experience under your belt. What's one piece of advice that you wish all your or any divorcing clients would hear when it comes to protecting their future financially and emotionally with legal planning?
Well, I mean, I would say written agreements are the best protection, as I said, whether it's for jointly owned property, whether it's a property that's held in a trust, basically basically it memorializes whatever the party's agreement is at the time that they're in agreement. And, that's the time to solidify, as you said, while the memories can change, and also either party can twist the facts of what their agreement was, to their own benefit if there's nothing in writing. So I think that's really the best thing because let's say jointly owned property, you can have a provision in there saying that, what happens if one party wants to sell? If, rather than have to go through a partition action because one party doesn't want to sell, if that agreement says that, if one party wants to sell, they just give notice to the other side. They have 60 days, let's say, within which to agree to buy out the other side. And if not, then the property gets listed with a real estate broker and gets sold. And then how the proceeds are distributed. I mean, that streamlines the process and eliminates the
It
need for
does.
suspension.
And I think so many people get faced say, well, let's put it in writing. And oh, don't you trust me? I'm not the kind of guy or gal who would ever do fill in the blank. And I think that putting it in writing, this is what I tell my clients, and it sounds like you do too. You put it in writing just to make sure you're on the same page.
Right.
That's that, and it's not about lawyering up or being suspicious or not trusting. It's about just being clear what each of you mean and what's going to happen if this happens, that happens, or the other thing happens. Because, hey, listen, none of us are here forever and we just don't know what's going to happen in the future.
Right. And people's preferences as to how they would like things to be distributed or whatever change over time. And, if both, let's put it this way, if both parties changed their position and they're now willing to agree to something that's completely 180 degrees the opposite of what they agreed to in the first place, that's fine as long as they both agree. But if only one of
Exactly.
them, if only one of them took a 180 change, then the other one should have the right to say, no, that's not what we agreed to. This is what we agreed to, and
Absolutely.
enforce it.
Well, Michael Goldstein, thank you so much for being my guest on Divorce Dialogues. It's been a pleasure.
Thank you so much, Catherine.